So this little video is focused on the importance in a criminal defense matter of filing a motion to suppress as soon as one gets in. As soon as one gets in, you file your entry of appearance, you plead not guilty, you file a motion for speedy trial, you file a motion for discovery, you file an omnibus motion to suppress. Later on, when more discovery is obtained, because initially all you may get is a probable cause statement that accompanied the arrest of your client. So there won't be forensics and transcripts of interviews and Miranda long forms or Miranda short forms or any of that sort of discovery. You get those items later. But by filing early, you place the state on notice that you're going to ask for any evidence that was obtained in violation of the client's constitutional rights be suppressed. That is a warrantless search. That is a statement given after the client, when in custody, expressed the desire to have counsel. And in this particular case here in Maryland, in Maris County, involving a sex crime, the client was arrested. He was placed in the interrogation room. The interrogation started. He was advised of his right to counsel, which is his right under the U.S. Constitution. He exercised that right. The police officer stood up and left the room. Said, "Well, I can't talk to you anymore," which is the right thing to do. He left. Our client was sitting for about 30 minutes. Cameras on him, and he's saying a lot of things. He's speaking to himself. He may have been having a mental episode or what have you. 30 minutes later, another detective comes in and says, "Good evening, how are you doing? How are you doing? I hope you're doing well. Okay, let's start. Let's see here." He never mentions the fact that his colleague had been in that room before, and his colleague had been told that the client, our client, wanted to exercise a right to remain silent until, of course, he had the assistance of counsel. And in that second interrogation, our client made some disclosures that were not helpful. And we moved to suppress, and we were successful. The circuit court's position was, after the motions hearing, where the state argued vociferously that he'd waived his right to counsel, by the second interview, was that once our client had exercised that right to counsel, the door was shut, could not be reopened. It was shut absolutely, and no further probing could be engaged. And so the position that all attorneys who are doing this for the first time, those who've never done it, certainly need to be aware of the applicable Maryland law. And to persons who look at this or who have criminal matters before the court, get a lawyer who can tell you chapter and verse that they've engaged in motions, such as motions to suppress, to exclude evidence obtained in violation of the right to counsel. Because there's some lawyers who go into court and they have not filed the relevant motions, they've not done the relevant research. Their clients get placed on the cross and they're crucified because of ineptitude. And so the moral of the story is, if you're arrested, you have to provide your name, your address, that sort of personal identification data, and you have an absolute right to say, "Thank you, officer, for doing your job." Do not protest, do not resist arrest. Just provide the particulars as to who you are, and then say that I would like to speak to my attorney. And of course, we're here to assist you. And the Christian law firm out in Bowie, been doing this for some time, and we have to make sure that your rights are respected, and so that you're not unjustly imprisoned because you didn't have the opportunity to exercise your rights or have your rights respected. Thank you very much.